Hi, and welcome to this first series about privacy by blockchain design. First of all, I would like to know what the big picture problem is here that we're trying to deal with.
The big picture problem is really personal data, I would say. So, coming from my background as a blockchain architect, I figured that just the technology is a bit too shallow for me, so I was digging a bit more into personal data and data protection with the GDPR becoming a more and more or an increasingly more important topic. And so the problem here is there are certain difficulties where the General Data Protection Regulation hasn't foreseen or hasn't had technologies like blockchain in mind when they formulated the text. Like the GDPR is very, it's so to say, it expects any technology that is used in the web and in modern society that it's rather a centralized or server client-based architecture where you can, without any doubt, always pinpoint where stuff is happening. So you can say, okay, there is the controller, there is the server, and there that stuff is happening. But when we look at blockchain, it's basically stuff is happening everywhere, and everybody is still doing the same thing, but that's just because they agreed on this protocol, but the general data protection regulation doesn't really have that in mind. And so when we are trying to be privacy preserving or data protection compliant, a lot of problems arise because the legal text actually states or expects us things to do in an old-fashioned way without explicitly stating technologies, but the way it describes how things are to be done, it's really hard to make it exactly in this way. And so when you want to use blockchain and still honor the principles of the General Data Protection Regulation, you have to do, let's say, some kind of legally sophisticated interpretation of what the GDPR actually wants, and then assume that it didn't have blockchain technology in mind, and then say, okay, but blockchain technology has potentials that I can harness for the better of data protection. And I think this is really the core issue where our research starts and where we then start to become more concrete in the workings.
Good. But I mean, taking maybe a step backwards, when it comes to personal data, what is it that, or what's the major issue here, or what are you trying to achieve? Maybe to set the context a little bit of what's been happening so far with personal data, um, why there is that problem in the first place.
Well, I think we have at least an international problem that different cultures and different regions have a different perception and also a different attitude what
Hmm.
personal data is. So as far as I understood it, the American, Western, maybe also a bit British opinion on the topic is that personal data, as well as any kind of data, is like a resource that is out there to be harvested. So like a tree. So basically, if you own the land the tree grows upon, you have the right to chop down the tree and use its resources
Hmm.
to your benefit.
Hmm.
And there, I think the European attitude that we see reflected in the GDPR is maybe a bit stronger influenced by the German and Austrian view on data protection and privacy protection, which this awareness probably also has been built a lot due to our due to recent history in the last century about what can go wrong if you have too much public data out there and everything is common knowledge. So the potential for abuse of the power that comes with having this information, that's really the awareness where this grew out of, in my opinion.
Mm. All
And
right.
so here it's more like also as I see the political and the legal trends at the moment is that there are forces in the working that rather say, nah, actually we have to think about something like ownership of data in the digital world.
Mm-hmm.
So the solution goes more in a way, or the way to approach this is rather that every individual, whenever you generate personal data by living and transporting those facts into the digital world, or at least reflect those things that happen in reality in the digital world, you're therefore creating data and value. I think that's obvious, and there we are in agreement. But who actually has the right to harness this data? Who has control over this data? There are things. There, I guess we have an international dispute at the moment where people don't agree, and the European attitude towards this definitely goes that the data subjects, so the populace, is definitely very important in this whole role. Like, who has to say about the data? So if something concerns my personal data, it's not that I dictate what happens with it. So there is also the public interest, which has to be considered. But at least if my personal rights or my dignity is touched by something that happens with this data, or maybe even value is generated out of this data, that it is of my concern, because that's my life that people are actually dealing with, or it's my life, or the value that I generate with just living my life and my lifetime and what I'm doing, and that I have some type of ownership on that value creation, or at least a say how this data is used to create value and stuff.
Mhm. So so I guess that's precisely what we will talk more about later, that blockchain by its nature can actually give back the power of data, the power over personal data to users. You've mentioned before that obviously there are some issues at the moment that are a bit more basic, let's say, or complex in some cases, of course, of compliance with law, GDPR, when it comes to blockchain. And what is quite interesting, I think, and we haven't mentioned yet, is that a lot of these problems are generated by the divide between the IT language and the legal language, and that there is a lot of misunderstanding going from one direction to another, that also globally leads to this distrust, or like lack of certainty when it comes to blockchain and compliance with data protection regulations. Can you maybe elaborate a bit more about this divide and yeah.
Yeah, I think we had a certain potential for conflict there for the maybe last 1 or 2 decades, that the law always feels like they're have to run behind a technology. So basically IT guys and the whole IT community is basically pushing forward this progress in technological advances, also having a huge impact on society, a huge impact on how people interact with each other, how people live together. Like, it also the value that people create for each other and also how they judge each other about what they're doing. And this happens more and more in a bubble for the legislator. So it's this like corporate environments where corporations, like fast-moving corporations with a much higher efficiency ratio in regard of time to act, at least, like maybe not in an outcome as a whole if you consider the societal value of it. But I think there is really this discrepancy where lawyers also still, or at least the majority of the lawyers maybe still think that there is this outside world that they have to regulate and to like conceal for the better, to people protected from this, and vice versa, that techie guys always feel so confined about the legal regulations, because legal regulation always has in mind what has been done, and if you want to do things differently, there is a lot of fear and uncertainty, like if the legislation or the government or the courts will approve of how things are done in the future. And I think there it is really time to grow together as a whole, because also the digitalization of the whole law industry is inevitable, in my opinion, because we have the technology to build digital contracts if we apply the same regulation to those digital contracts that we have for the paper contract world as we have nowadays, because they both follow basically the very similar ways of thinking. So the legal thinking as well as the IT thinking, at least as I can tell about the legal way of thinking, since I'm not a fully finished lawyer. I just took a couple of courses about university and learned a lot by my good friend who is a researcher at law. So I can really say it's both. You start with certain rules and a certain rule set where you can say, okay, that's our foundation, that's where we start. And then you just try to make up rules and build a stack of several things that you build upon each other, and then you have a certain pattern with which you check if those rules hold up to whatever use case or whatever particular case you throw at the system. And so I think the base similarities are there. It's just what's the biggest hurdle is the willingness and also that realization of lawyers and computer scientists alike, that they are actually trying to solve very, very similar problems. They might have a different angle and they might have a different approach in the tools that they use, but I think that's not how it has to be, and I think there is a lot of potential to move forward and to actually take the best of both worlds and fuse them together and move forward with products, software, ideas that create a lot less friction in the first place, because it has been thought from both angles into one idea and then manifested in the world in that sense.
So at the moment, it all comes down a bit to building awareness, right? How do you think that we could achieve this? Like moving towards better awareness among both legal and IT professionals, that cooperation is crucial.
I mean, first of all, we need more people to do what we currently do, to get in the topic, to show interest for it, and then also to talk about it, to approach other peoples with that idea. Because I think the idea is not really that crazy or revolutionary that we have. Like, we've seen behaviors like this again and again throughout history, and whenever people start collaborating instead of fighting against each other, then things turn out for the better. So
Mm.
I think the answer lies within the question.
Yeah. I'd also be interested in a few examples of what the difference between the IT language and the legal language, like what can it look like to have this discrepancy? And since we are in the topic of blockchain, we've picked out a few words that we think can be interesting to have a closer look at from this perspective.
Mm.
So I guess the first example that I really think is very interesting is erasure.
Yeah, erasure. I mean, what pops to mind first when you talk about the legal side is the right to erasure. So because this is a big issue with blockchain's immutability property, which I want to say something about later, but that will probably pop up in the whole erasure discussion anyway. So when you look at the right to erasure, most people, like when you're a techie and you hear this, you say, okay, I need to properly erase all data, and so that's what I have to prepare for. So if I want to do this on a blockchain and the blockchain is immutable, we're going to have a big problem. So, but the interesting thing is that technical erasure can go from you mark something as deleted in the file system, but you don't actually delete the sectors on disk where the data is written. So basically, if you have a special tool, you can just, even if the file is deleted, and I'm not talking about stuff that's being in the recycle bin, I'm talking about stuff that has been properly deleted, the information is still there. What you basically need to properly erase and to forget data is you need to override all this data with either only zeros or random ones and zeros. Then you have proper deletion. I mean, you also have the option to destroy the hard drive. Just hit it with a hammer, you know. But what the law actually wants when you say the right to erasure is that data is not publicly available anymore. So let's say somebody hacked your phone and leaked some naked pictures of you in the internet, which is a bad example because you would want everybody to delete it. I don't wanna throw up that uncomfortable argument here. So I'll switch to another example where somebody had a house and he had a mortgage on that house. And then somehow this whole thing blew up in his face. But then 15 or 20 or 10 years later, it was a significant amount of time later, when you Googled his name, this entry was still one of the highest ranking hits on the Google search engine. And that's basically where the court said, okay, this lies so far in the past that the public interest to this knowledge is not really justifying the fact that this information is out there and the fact that this individual needs protection and also has the right for things to be forgotten. That's when they ruled that this search result has to be taken out of the Google search index. So they didn't require the website which originally hosted this information to delete the information. They just required that Google took it out of the index, so the public availability isn't the same as it was before. And as we see here, the right to erasure has nothing to do with actually deleting the data itself on disk. So this is really where erasure in the legal sense and erasure in a technical sense can mean something very, very different, because the lawyers are always looking on the real life impact. They are looking at what consequences has this for people, and is this something that we want according to the law. And techies are usually really looking like at the deep stack where they say, okay, erasure, is this erased or not? No, it's not, or we have a problem. But that's where I say it's not that simple. You need You need to find a common language. When a lawyer talks about right to erasure, you can't assume that he's talking about the same thing that you learned at university as a computer scientist, and vice versa. So another nice example is a controller. Like for a computer scientist, it's usually a part of the stack from a model view controller setup. And for a lawyer, a controller is the guy who is in control and is determining the means of processing of personal data by using an automated data processing system. So it can come up to the same thing, but it can also, in the end, mean something very, very different. And I think that's just something that, as a first step, it's very important that as well lawyers and computer scientists are aware of this. So at least you can identify potential misunderstandings when you're talking with one from the other profession, and don't just assume he's a person that's just sticking with his ideas and doesn't want to communicate with you or doesn't want to see your point. Because usually we do, we just need to make each other understand that, hey, this is not an argument where I have a stupid opinion, I'm just using words differently, and we have to first clear out what we're talking about before we can come to good solutions.
Yeah, so now I guess what would be really interesting is to know more about the paper that you've published, Privacy by Blockchain Design, together with your friend Michael Colline, who is a legal researcher. Can you maybe, I guess, just introduce the broad idea around the paper, and yeah, let's start with the idea.
Yeah, so starting at the point that I described earlier with basically how we want to find a common language and bring law and computer science closer together, especially in the regards of data protection. We wrote this paper, Privacy by Blockchain Design. We're going to leave a link for you in the description. There we were looking for a nice use case where we basically could start to develop a methodology how to better design software and basically tackle some of those challenges that occur in the whole tension field of legal tech. And so what we did, we looked at the consent according to the law, the consent that you need when you process personal data, and also the requirements that are formulated regarding that consent. And we started approaching this with taking the law itself as the non-functional requirement for the software that we have. So instead of a business case and a company use case where earning money is the intention of doing it, we just took the law and says, okay, the law's intention is to lay the foundation for a peaceful and cooperative society and how people should interact with each other, and said, why don't we start designing software and programs, and we actually ended up with doing design patterns, but we derived those directly from legal specifications that are written down in the law.
So thanks a lot for this
That's
interview.
all already?
Yeah, I mean, that's all we wanted to do for this first article. Because I think for one article, it's already probably pretty long.
Thank you so much for having me here and taking the time to ask me some questions and
taking the time to listen to the answers.
Exactly. Taking the time to listen to me, going along and forming the thoughts up in my head until I can actually produce words. Also, thank you very much for your patience, and I hope I could convey the one or interesting thing to you. If I didn't, Anja, most certainly has.
Well, yeah. Um, Thank you. Thanks a lot. And until next time.
Bye bye.
Bye.